The argument of the first accused person is that this shot in this court is faded yellowish. I had the benefit of seeing that shot. There is nothing faded yellowish. It is a khaki brown shot. This court was told khaki is not a color. It is a mixture of nylon and others. The color is not khaki, the color is brown. I had the benefit of looking at that white piece. It's a relatively big piece, and one cannot rule out that it may and was the council. I did also take cognizance of one important thing which none of the parties here submitted to, but I am expected as a judge, as a court, to comb through all the evidence, and I did. There was a lot of contestation on the shot, but it was very clear. No one disputed that the first accused person is supposed and was wearing a maroon cap. So a lot of questions was on white council, and the brown shot. No question on the maroon cap. Yet this maroon cap meets and joins right from the house where the first accused left. The house help says he wore a maroon cap. Jenny's at Roadhouse, he wore a maroon cap. You go to Chelagat, he had a maroon cap. You go to the guard at Ramuria, Haron had a maroon cap. You go to the witnesses who were in that house, he had a maroon cap. A maroon cap has been produced in this court. Does the accused person say it's not mine? No evidence to that effect. I have also considered the submissions by the first accused counsel that the cloths that have been brought to this court are generally ordinary clothes that you can't get in the market, and that they did not have any specific identifiable marks that would pin the first accused. And my simple argument is this. Really, when clothes are manufactured in the factory, they manufacture them in bulk. The only way I will distinguish you are, the other day I saw a newscaster wearing I will not tell you who, a blouse like mine. And I'm sure any one of us can speak to the fact that we wear clothes that are manufactured in the same place, isn't it? The only difference is the size. So if you want to say that my clothes have an identifiable mark, then I should put that mark for that purpose. Otherwise, clothes are just clothes. So the fact that these clothes did not have any marks that would say this cloth only belonged to so and so, for me was not a tenable argument. But my findings on that is that there is corroborative evidence as to the cloth which the first accused person was wearing on the material date. Please allow me to move to the next issue. In that reading, I've done away with quite a bit of material, so you will not wait for too long. Summarized quite a bit of it. And so the next question is whether the accused was in the first accused was in the deceased house on the material date, and whether he was the last person to be seen with the deceased. Now, considering the evidence of PW7, Owen. His evidence is that the first accused person was in the deceased house. Waridi did not testify, and nothing much can fall on his evidence if he has not been tested on it. But the strongest argument the accused person is advancing is that, look, there were these two other male persons. First of all, there were other people like in our Maribe, the Lee Owens, the Kakas. Why were they not also investigated? But he advances another argument. The strappings that were used to tie the deceased, the evidence of the government analyst is that it revealed DNA of two unknown males. These are the people who were in that house, and that Dominic Harrow. Allow me to make my observation. But before I do that, back to Lee Owen. You know, Lee Owen is the witness who says, I was with the first accused person. And I needed to find out, why is Lee Owen, how can the court admit or disallow, or what is the weight that this court needs to put on the evidence of Lee Owen as the one who saw the accused in the deceased house? And this is what Owen said. That first of all, he stayed with the first accused person in the deceased house for over 1 hour. That was his evidence. Secondly, the first accused person was using coded language. Thirdly, he had a beard. And fourthly, he had brownish eyes. Then he says, in their conversation with the first accused person on that day, these are the words the first accused person said, and I'll quote, that in their conversation with the first accused person in the deceased house on that day, these are the words that the first accused person said. And I've quoted them verbatim. In reference to another country where they account for everybody, not like in Kenya where you can come and do something and just disappear and someone can impersonate, since we don't have a database. In reference to another country where they account for everybody, in Kenya you can come do something, just disappear or impersonate somebody, since we do not have a database. And then, of course, Owen says he identified him on the parade. I'll come to the parade. Other than the evidence of Owen, I sought to find out whether there is any other evidence that would place the accused person maybe in the deceased house. And I came across the evidence of PW25, Chief Inspector Frederick Ngahu. Attached to the Directorate of Integrated Command and Control Center, and he brought records of the movement of vehicle KCA E03E, the second accused vehicle which the first accused person was using, had indicated, without me having to read in details, that this vehicle was within the subject time and the set time within the Dennis Prit area, and that is within the vicinity of the commission of the offense. And so, it is the finding of this court that there is evidence the first accused person was within the vicinity of Dennis Prit area, the vicinity of the commission of the offense, and that corroborates the evidence of Lee Owen of his presence in the house of the deceased. But I have looked at his submissions about the two male and the unknown, and I took time to think about this. And this is my findings and my observation, that we are talking about DNA on straps. And I'll repeat that. We are talking about DNA being found of male on the straps. We are not talking about DNA on the body of the deceased. Hear me out. Straps, I've taken judicial notice of the fact that there are items that can be purchased from a departmental store. And they can be handled by more than one person. The seller, the buyer, and the end user. And therefore, the possibility of DNA of more than one person being found on these straps is not far-fetched. It's not unimaginable. If we are saying that this DNA was on the body of the deceased, it would put beyond reasonable doubt that those people were in that house and had contact with the deceased. In any case, may I take all of us back to the particulars of the charge? They say, jointly charged with others not before the court. I say no more. But finally, before I move out of that area, the question that we must ask ourselves is, does the fact that there may have been other people who are still at large exonerate the first accused person from blame? My answer was in the negative. Was the first accused person the last person to be seen with the deceased? The doctrine of last seen was discussed in the case of Kimani versus Republic, where the Court of Appeal said this, and I will read it because it's important. The doctrine of last seen alive is based on circumstantial evidence where the law prescribes that the person last seen with the deceased before their death was responsible for his or her death, and the accused is expected to provide an explanation as to what happened. In the Nigerian case of Achi versus Tet, 1993, the court relied on the case of Eastman versus Tet to discuss the doctrine of last seen. And this is what the court said, and I quote, "In the case of culpable homicide, as is in the present one, where the doctrine of last seen has been applied, the law presumes that the person last seen with the deceased before the death was responsible for his death, and the accused is expected to provide an explanation of what happened." The last seen doctrine stands as negation. I will repeat again. The doctrine of last seen stands as a negation and an exception to the doctrine of presumption of innocence. It is therefore tried law that where a victim was last seen by the accused and is found dead, the death of the victim will be presumed, and it will be presumed that the last person he was last seen with is responsible for his death. Therefore, if the first accused person is the one who was last seen with the deceased herein, as testified by Lee Owen, then the first accused person will have the burden to explain what happened to the deceased. Please have a look at the case of AJAABU versus Tet, 2006, LCN. You'll find it in my judgment. It is the finding of this court that the first accused person was in the deceased house on the material date. And he was the last person to be seen with the deceased. The evidence of the protected witness is that Hanun, whom he identified on the parade as the first accused person, left that house at 23, that's about 11, and no one else went to that house. It is the evidence of this witness the deceased Sudanese boyfriend was not in Kenya. And there is evidence that this deceased person was supposed to be traveling the following day to go to Dubai to meet the Sudanese boyfriend on business and holiday. The next issue I'm considering at this point is whether the first accused person had a gun on the material date and whether he used it to subdue the deceased. May I have a little more water? The evidence of Brian Kasaine Spira, corroborated by the evidence of no other person than the first accused person himself, is that by 19th of September 2018, the first accused person was in possession of a gun. That gun belongs to Brian Kasaine Spira. And so, it is undisputed that on 19th of September, the first accused person was in possession of a gun belonging to Kasaine, PW17. In fact, Kasaine testified that the first accused person had earlier on borrowed this gun to go on what he said a refresher training, returned it, and then he borrowed it again. And according to Kasaine, and this is important, he was supposed to return that gun after 2 days, but he did it. And so, by 19th September, he had a gun. That corroborates the evidence of Jennings that when they left Roadhouse, the first accused person opened the dashboard of the car and removed the gun after putting a white council on top of his cloth and picked a taxi and went where he was going. And so the question is this: if he was armed with a gun and the gun was not used to kill the deceased, what was it for? I am in concurrence with the submissions by the prosecution that the gun was intended and used for the purposes of subduing the deceased. I'll quickly move to the identification parade. The identification parade was conducted by Chief Inspector Arama. Again, I'm fast tracking, so I'll not go through the rules of a parade. There were witnesses when I looked at the identification parade, and critically so, I noticed the following. One, the identification parade listed 4 witnesses who I do not understand how, but anyway, is there, included Kayo, investigating officer. But the investigating officer then was not given an opportunity to go to the parade, but he's indicated as a witness. As I told you, I looked at age and everything that I needed to look at. And the identification parade form has a provision where a suspect is supposed to indicate whether he or she is satisfied in the manner in which the ID parade was conducted. According to the Inspector Araman, who testified as PW28, the first accused person was satisfied that the parade was well conducted. However, it is notable that the first accused person did not sign on that form where he was supposed to sign to confirm that he was satisfied with the parade. Secondly, it is in evidence that PW7, and he admitted Owen, before he went to the identification parade, he had seen the photograph of the first accused person. And so that then must have aided and abetted him to quickly pick up the first accused person from the parade. Thirdly, whereas the officer who conducted this parade, who is Inspector Araman, says that the first accused person was not in a sling, contrary evidence has been given by the prosecution witnesses, including the protected witness. And so, the contradictions can only go to the benefit of the first accused person. And in just emphasizing on the need to conduct a proper identification parade and for the benefit of the office of the DPP, join me in the words of the court in David Mitawanja and Others versus Republic. Quite good read on identification parade. And this is what the court said. The purpose for and the manner in which identification parades ought to be conducted have been a subject of many decisions of this court over the years. And it is worrying that officers who are charged with the task of criminal investigation do not appear to get it right. As long as 1936, I don't know whether anyone of us was there, the predecessor of this court emphasized the value of identification as evidence and would depreciate considerably unless an identification parade was held with scrupulous fairness and in accordance with the instructions contained in the police force standing orders. They made reference to the case of Ara versus Mango. And so, the court says this: it is not difficult to arrange a well-conducted parade. The orders are clear. If properly conducted, especially with an independent person looking after the interests of the suspect, the resulting evidence is of great value. But if the parade is badly conducted and the complainant identifies a suspect, the complainant will hardly be able to give reliable evidence of identification in court. Whether that is possible depends on clear evidence of identification. I will not finish the quote. It is the finding of this court that the manner in which the parade was conducted was fraud, and therefore this court cannot find the first accused person guilty of the offense he's been charged with based purely on the evidence of the identification parade per se. The last question is whether this first accused person committed the offense. And I'll pick on issues I raised and that I've not dealt with, so I'll not repeat what I've already dealt with. The first argument of the first accused person is that he can't have committed an offense in 10 minutes, and that is what I want to address now. And that brings in the issue of contradictions on the time Haron entered and exited from the house of the deceased. It is not in dispute that the entry in the occurrence book at Ramuria Gardens indicates that Haron entered the premises at 23:21 and left at 23:31. 10 minutes. That is not in dispute. And the prosecution explanation to the same is that the entry in relation to what time Haron entered the house is erroneous. That is an error. So I took a journey. I'll tell you the journey I took. My journey started with Jennings. Jennings states that they left Roadhouse with the first accused person at 8 p.m. Right? He goes on to state that he then went to a petrol station after the changing of clothes. I've spoken to that, where the first accused person left him waiting with instructions that if the second accused person needed the vehicle, please give it to her, and took a taxi. According to Jennings, by the time they were parting with the first accused person, it was 8:30 p.m. Then we come to the evidence of Lee Owen, who then says when he arrived in the deceased house at 9, the first accused person was there. Now look at this evidence. Lee Owen says, in fact he says, I entered when the 9 o'clock news were on. And the entrance is saying he entered 23. So let's just continue this journey. They leave Roadhouse at 8. They part at 8:30, and by 9, according to Owen, he's in the deceased house. Then, according to Owen, he leaves the first accused in the deceased house. But even departure from the first accused house does not seem to an issue. So the question I posed for all of us to ask and answer is, if this first accused person left Jennings at 8:30, and by 9 he was in the deceased house, is it possible then the entry that shows he entered at 11 o'clock was an error? The evidence of the timings corroborates a finding that there's 23:21 was an error because it does not tie with the movements and the evidence of the witnesses. And so for me, my finding was the argument that I couldn't kill in 10 minutes is not tenable. And I pose the question, if indeed the first accused person, before I even pose that question, I have made an observation that this court visited the scene. This court had the benefit of appreciating the distance from Roadhouse to where the deceased was staying. Less than 15 minutes walk. And so if really indeed this first accused person left Jennings at 8:30, he would not have taken more than 15 minutes to be in the deceased house. And that corroborates the evidence of Jennings. By 9 o'clock he was in the deceased house. And so my conclusion is the argument about 10 minutes, not tenable. Now, the forensic evidence. Evidence has been produced in this court that the shot which was collected from the house of the first and the second accused had blood stains. Subjected to forensic exercise, it is the evidence of the prosecution that the blood on that shot was the deceased blood. Lots of issues are also on that shot. Is it the shot that was collected from the accused house? The accused says no. I ask myself as a court, so are we then saying the police went and bought a shot? Are we saying the police substituted? If they did, where did they find the blood of the deceased to put? Then the accused person advances a further argument. Surely, if there was blood, it should have been seen. I go back to the evidence of the analyst, and he says, and I quote, I think, if I can get it. Yes, here we go. My paragraph 212, my judgment. In cross-examination by the first accused, the analyst stated that the blood stain on the shot was a small spot on the front. A small spot. So one asks, if I were to pick something, was it then generally visible that the scene visiting officer who took a photograph of it, the people who are collecting it would have said, oh, this one has blood. He said it was a small spot. Then there was a question on the storage and the chain of handling. And this is what the witness said, that all XBs are kept in high security cabinet, and this was kept in the high security cabinet marked JKZN. Okay? And in my finding, and it is the finding of this court, no reason has been advanced why the investigating officers would have done away with the shot which they collected from the accused house, found a different shot, subjected to forensic examination, and is found to have the deceased blood. It is my finding that this shot, which was taken to the government analyst for forensic examination, is the same shot which Pamela, the house help, has identified, is the same shot which Jennings, who was at Roadhouse with the accused person, has identified, is the same shot Chelagat, who was with the accused on that day, has identified, is the same shot which is entered in the inventory. At this point, I want to go to the evidence adduced against the second accused person. I don't need to replay what the state and the prosecution said. I've already spoken to it. But I want to bring in the evidence of the second accused person and the submissions. It is her evidence and the submission is that I did not know the deceased. It is her evidence and the submission that I had no reason to kill her. In fact, she says in her submissions, if I knew, leave alone killing, that there was a plan to kill her, the conscience of my banks would not allow me to keep quiet. I would report. She says in her submissions, yes, my phone went off, but says, my phone going off is not commission of a crime. And it was not switched off because I was committing a murder. She says in her evidence and submissions, I gave the first accused persons the vehicle. Yes, it was my vehicle, but I have no control over it when he has it. She says in her evidence, no forensic, no data, no eyewitness places me at the deceased house on the material date. She says in her evidence, the people who visited the deceased were of male gender. I'm of a female gender. And no one has said there was a lady who visited the deceased on the material date. She says I've explained throughout, where I was throughout, from the time I reported to work, to the time I joined the interview of the former governor, to the time we went to Q launch, and then went to 40, to the time I went home. It was the duty of the prosecution to displace my alibi. They have not. And she says, if they're asking this court to convict me for aiding and abetting or an accessory after the fact, there's no evidence I did. And if there is any evidence of anything I did, it has nothing to do with the murder. It could have something to do with the shooting incident. And tells and analyzes and crushes and says the murder was on 19th, the shooting incident was on 20th. The murder was by a sharp object, the shooting was by a gun, excuse me. And so they are not related. I am not accessory after the fact. I will not read for you as an accessory after the fact. I will not read for you what the sections on aiding and abetting. You will read it for your own benefit when we come to copy of my judgments. As I read, I see a few errors, we will have them corrected. And so for her, the sum total of evidence adduced, either through oral or documented evidence, does not show that she was involved in the murder in any way. She says again, I did not witness the burning of any cloth, and then goes on to say, if anything is the case anyway, the clothes were burnt in a public place, and the investigating officer did not establish whose place it was. Then finally says this, my relationship with the first accused person, and she says, then, my relationship with the first accused person then was that of cohabitation and aiding him to get treatment after he was shot. It's a constitutional right under Article 43. If anything is the case, you can't take a gunshot wound lightly. She says, by any stretch of imagination. She then crowns her submissions by coming to the doctrine of last sin and says, if there is anyone to be asked as to what happened to the deceased person, it's the people who are last seen with her, who are Waridi, Kaka, Owen, and the first accused. Let's look at the evidence. The defense by the second accused person is an alibi defense. The law is settled. One, it must be raised at the earliest, and two, it is the business of the prosecution to displace it. So when the accused person says, I woke up in the morning, I did 1, 2, 3, and removes themselves completely from the commission of the offense, it is the prosecution to say, no, you did, what you're saying is not true, you are. And let me tell you why that is the law. Please join me in the case of Kiare versus Republic 1984. This is what the court said. An alibi raises a specific defense. And an accused person who puts an alibi as an answer to a charge does not in law thereby assume any burden of proving that answer, and is sufficient if an alibi introduces into the mind of a court doubt that is not unreasonable. Right? But it suffices to note that relying on an alibi defense, the entirety of the prosecution, evidence must be considered, either direct or circumstantial, so that the court is appraised to establish whether that accused person was elsewhere and not at the scene of crime. Further, the conduct of the accused and the decision to raise an alibi during the defense hearing case, if that be the case, should not escape scrutiny of the court. ADVERTISE versus State, failure by the police to investigate and check liability of alibi would raise reasonable doubt in the mind of a tribunal and lead to the quashing of a conviction imposed. Ricky versus State, Free State High Court, the acceptance of the evidence on behalf of the state cannot by itself be sufficient for rejecting alibi evidence. Something more is required. You can read more on that. My last few pages will be dealing with the conclusion, but I want to take a tour, because at this point I posed a question: was the second accused person involved in the commission of this offense? I said, hold on. I have then moved to discuss an issue that has played in this matter and has been identified as distinct from the matter before the court, and that is the gun shooting incident. So let's move to the gun shooting incident. By an OB number 79 of 21st of September 2018, produced in this court as prosecution exhibit number 33, the first accused person reported at Langata police station that while he was going home, Royal Park Estate, he was shot by thugs in what was described as a robbery. Subsequent thereto, he wrote a statement to that effect with the police. Similarly, the second accused person on 28th of September 2018 wrote a statement in support of that report that the first accused person was shot by thugs while going home. 28th September, I've had the benefit of that statement. It's marked as prosecution exhibit number 109. I have read it in its entirety. It suffices to note this. On 29th, the following day, the second accused person writes yet another statement on the shooting incident and retracts what she has said in the statement of 28th of September 2019. This time her evidence and her statement is that no, he wasn't shot at the gate. It's an incident that took place in her house. Now, Brian Kasaine Spira, the owner of the gun, testifies that while asleep, the first accused person went to his house groaning in pain and said, "Oh, Brian, please rush to my house and secure the gun." Remember, the gun belongs to Brian. He's given it to the first accused person. The gun has fired or been fired or whatever. So Brian rushes to the first and second accused house and secures the gun. What does he say about his observation? He says, "I found blood on the floor, and that when the first accused person came to my house, He had blood all over the chest. Who else speaks to these events? The house help. She says that she had noise, and when she went to check, she found blood, she found a gun, and her concern was, first of all, to secure the child from that scene. But she says she saw blood. There is evidence of PW27. Yunus Mohammed, who was the caretaker at Royal Park Estate, he says no. If there was a gunshot incident at the main gate, I would have known as a caretaker. There wasn't. Kasaini comes back. Remember, Kasaini was a neighbor to the accused persons, and he says if there was a gun incident in our estate, ingewekwa kwa mtandao ya estate association WhatsApp group. It wasn't there. What does that say? It is the finding of this court that the report made to the police by the first accused person, the statement made by the second accused person on 28th of September was false. He lied in his evidence in this court, before this court. Now, what is informing this lie? It is very clear that Brian Kasaini had given the first accused his gun without authority. And so according to Brian, when he realized that his gun has been used, his first concern to the first accused person was, what are you going to do? And the words of Brian in his evidence is that the first accused person told him, do not worry. I'll take care of that. I will report it as a robbery. Now, let's look at the legal, natural, probable, and moral consequences of a lie. The case of Kinuthia versus Republic, 2003. The Court of Appeal had this to say. I will repeat. Kinuthia versus Republic, 2003, EKLR. The court had this to say. I quote. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. I will repeat. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. The court went on to say, in a criminal case, a witness should not create an impression in the mind of the court that is not a straightforward witness. That if a witness raises suspicion about his trustworthiness, or does something which indicates that he is doubtful, he has doubtful integrity, he will be deemed to be unreliable, which makes it unsafe to accept his evidence. Please also look at these other cases. Duno Kimani versus Republic, MTG versus Republic. My analysis of the evidence. In relation to this issue of giving false or denial, the first accused person says, I'd never met the deceased. Court data shows he met the deceased. The first accused person is alleged to have told witness number 7, Owen, I stay in Emali. Evidence reveals the contrary. The first accused person gives the reason why he's wearing a kanzu and says, I'm going to meet people in Isli, from Muslim community. He does not reach Isli. It turns out the kanzu was worn, left, went where he went, came back. And in fact, by the time he's going to meet the second accused person and the others in Westlands at midnight, he has also removed the kanzu. for training, the gun is found evidently at the time the offense is being committed, at the scene of the offense. And of course, his own confession, I lied about the gun shooting. The second accused person contradicts her own statement by the statement of 30th and says, 29th, now I'm clear in my mind. The statement I gave you yesterday was a lie. Statement of 28th was produced as exhibit 109. Statement of 29th was produced as exhibit number 10. Once it's produced in evidence as exhibit, I use it. Before I move to the very last tale of my judgment, allow me to address the issue of contradictions and the law. It is the first accused, and by extension, of course, the second accused again says, look at all these contradictions in the case of the prosecution, and found that the prosecution have not proved their case beyond reasonable doubt.